Good evening, everybody. Let's start the story. So, 45 years ago, on this same day, there was one letter which was written from one Safdarjung Road and was addressed to Rashtrapati Bhavan. And after that letter, the emergency was imposed on the next morning. The freedom was curtailed. We see many landmark judgments, many incidents which followed that emergency. Now, since today, we at Niti Manthan have our office at the midpoint of those two places, one Safdarjung Marg and Rashtrapati Bhavan. It gets important to know the story of that letter. What was written in that letter and what prompted the author of that letter to write so. So today, for next 1 hour or so, we'll be discussing the story which prompted the author of that letter to write it and what followed in the national life of India. But before starting the story, it is necessary to set the plot, a plot for the emergency. What was emergency and why was it required in the constitution at very first place? So historically, in India, it was culture which was an adhesive factor, which ensured that India remains one as a nation. And since time immemorial, we had states having autonomy, but India remained as a nation, one strong nation. But towards the end of first millennium of after Christ, towards the 900 AD, this culture was attacked by some foreign powers. Some were religious fanatics, and there was a constant attack on this culture. This was followed by the English traders, and by the 20th century, the English started saying that India is a nation in making. India was never a nation. It is only after we, the English, came to this land that this nation started developing. And we are responsible that India is becoming a nation. So, this was the conception by the British, which was purchased by many Indian leaders also. Now, when when English decided that they will leave, there was a confusion as to whom will they transfer the power. The viceroy or the governor general of that time was Lord Wavell. So Wavell decided that there would be one nation, no partition, but there would be two electorates with strong states and weak center. But these electorates were to be formulated on the lines of religion. There would be one separate Hindu parliament, there would be one separate Muslim parliament. It was not acceptable. The Congress rejected it, although Jinnah accepted it. But since Congress rejected it, was not amicably accepted. So Wavell's cabinet mission plan fell, and with that, Wavell also departed from India. And then came Lord Viceroy Mountbatten. With the arrival of Mountbatten, there were talks that now even English want two nations. And this was materialized on June 3rd, 1947, when Lord Mountbatten proposed and the Indian Independence Act 1947 came into being. This act proposed that now there would be two separate unions and the paramountcy of the British will lapse. So even the small states, the independent states, which were ruled by the princes, princely states, would be having a free choice either to go with India or to go with Pakistan or remain independent. Now it was the time to have a strong union, strong country, and a strong center because the culture was no more intact. It was attacked from right, left, and center. So it was difficult to have, and it was not even acceptable by many that culture should be the adhesive factor. And the states were loosely there, and many states were adamant to leave the nation or adamant to remain independent. So it was necessary to have a federal structure, but a federal structure of a nature which is sui generis for this country. So we came up with what was called, and which my professor of the constitutional law, Professor A.P. Singh sir, also says that it is a fair weather federal system. As long as the weather is fair, the sun shines, we remain as a federation. But moment the dark clouds overshadow the country, the federalism comes to down. The federalism goes, and we are a single union. So, in order to advocate this theory of fair weather federal system, our constitutional makers introduced the provision of emergency in the constitution. There are three kinds of emergency in the constitution. First being Article 352, which we'll be discussing today, under which the emergency can be invoked when there's a threat to the security of India. It is the security of India, not the security of the government. Neither it's the security of the political party in the government. It's the threat to the security of India. The second is Article 356, when it's the breakdown of constitutional machinery in the state. We also call it state emergency, or in the language of media, in the language of news channels, president's rule. And the third kind of emergency, that is the financial emergency under Article 360. While Article 360 has never been invoked till today, there was a situation in 1991 during the government of PV Narasimha Rao when we had the forex, the foreign exchange, only for 7 days. So the situation was there that 360 might be invoked, but it was not invoked. Even before this lockdown, or in the initial phase of the lockdown, there were some speculations that there may be, they may invoke, the government may invoke 360, but it didn't happen. Regarding 356, when it was discussed in the Constituent Assembly, Pandit Jawaharlal Nehru said that this will remain a dead letter in the Constitution. He said that I am sure that the state emergency will never be invoked. But after the Constitution came into force, after the first government came into force, the Union government in 1952, after first general elections, there were all the state governments were ruled by one single party, that was the Congress party. But moment first non-Congress government came, it was Pandit Jawaharlal Nehru himself who invoked Article 356 for the first time. It was in 1957 to overturn the government of EMS Namudripad in Kerala. And after that, till the year 2000, 20 years ago, till the year 2000, Article 356 has been invoked for more than 100 times. And the third kind of emergency, which is the national emergency, about which we'll be discussing today. This has been invoked 3 times under 352. Now, 352 also talks about 2 kinds of national emergencies. One is the national emergency, which is pan-India. So that emergency is invoked throughout the nation. There is another kind of national emergency which is invoked in a particular region, particular part of the country. For example, Punjab. So during 1980s, there was disturbance in Punjab. For example, Jammu Kashmir. So in late 80s and 90s, there were disturbances in Jammu and Kashmir. So the national emergency is invoked in particular regions. But as far as pan India national emergency is considered, it has been invoked only thrice. First national emergency was invoked by Pandit Nehru in 1962, on October 26, 1962, when Indo-Sino War, the India-China War, was taking place. And this emergency was revoked in January 1968. That means that even 1965 India-Pakistan war was within this period of emergency. And within this period of emergency, India saw four prime ministers. Pandit Jawaharlal Nehru, then Lal Bahadur Shastri, then Gulzari Lal Nanda became interim prime minister twice, and then Mrs Gandhi. So there were four prime ministers who took the charge of the PMO during the first national emergency. The second national emergency was invoked in December 1971, which was again India-Pakistan war, the war for liberation of Bangladesh. And very interestingly, this emergency was never revoked. And the third emergency, which was invoked on this very day in 25th and 26th of June 1970s. Now, in my personal view, Mrs. Gandhi was not having a good legal advice. And it is a fact that she didn't take her law minister into confidence. Gokhale was her law minister, and he didn't know that emergency is to be invoked. He came to know about emergency in the morning when cabinet meeting was called. So he was not aware that some emergency is going to be imposed. But if there would have been a sound legal advisor with Mrs. Gandhi, who would have some political acumen also, he would have suggested Mrs. Gandhi to modify the emergency which was already there. As the 1971 emergency was never revoked, so it was already there into existence. A sound legal advice would have been that you just modify that emergency and take a fresh order under Article 359, Clause 1 for the suspension of enforcement of fundamental rights from the president. President was hers, the stamp president, Mr. Fakhruddin Ali Ahmed. So, advice would have been just modify the terms of the already existing emergency and take a fresh order. But it was not done, and which costed her a lot in the political circles, a lot for the Congress party, and a lot in the sheer negative sense for the country. And because of this, maybe because her political end was near, as it was presumed at that time, or as it was considered in 1977, that it is her political end. It was said that, as Ramdhari Singh Dinkar also said in Rashmilati, कि जब नाश मनुष्य का चाहता है, पहले विवेक मर जाता है. So she didn't modify it, but she issued a fresh emergency. She made the president proclaim a fresh emergency. But why did she requested the president to impose emergency? What was the story behind her making the president impose emergency? So this is the story of emergency which we'll be discussing today. And when we discuss the story of emergency, there are many other stories which are important as far as the law of the land is considered, as far as the legal principles are considered, as far as the constitutional principles are considered, which cross the path with this story of emergency. Be it the stories of judicial appointment, be it the stories of federalism, be it the stories of basic structure, be it the stories of amendment to the constitution, or be it the stories of human rights jurisprudence. There are many stories which are crossing roads with this particular story of national emergency of 1975. But we'll be trying to deal with the main story, the legal anecdotes of that story, and here and there we will be seeing what were other stories. So, the elections for the fifth Lok Sabha were scheduled in February 1972. Everything was going correctly as per the correct pace, 5 year each government for 5 years. So first elections took place in February 1952. It was a long process. It took more than 1 year from 1951 to 52. Uh, so after 20 years, the election for the fifth Lok Sabha were to be were scheduled in February 1972. But Congress party underwent a split. There were now two Congresses. There was one Congress which was led by the stalwarts of that time of Congress, K. Kamraj, Morarji Desai. And there was another Congress which was led by Mrs. Indira Gandhi, the then Prime Minister. So one was Congress O, the Congress organization. So they said that we are the original Congress. And there was Congress R, which was also called Congress I. I stands for Indira, which said that we are the original Congress. So, in order to prove that she is the main boss, the powerful person, she preponed the elections. And the elections were scheduled, which were earlier scheduled in February 1972, were now scheduled in 1971. So, fourth Lok Sabha was dissolved in December 1970. Elections took place. And Mrs. Gandhi got a thumping majority. She got 352 seats, while the single largest party in opposition uh, was Congress O, led by Morarji Bhai Desai, which had 51 seats. So clearly, Mrs. Gandhi was in power. But Mrs. Gandhi contested the elections from the seat of Rai Bareli. Rai Bareli has been the traditional seat of Congress party. Even today, there is only one seat in Uttar Pradesh which Congress party has. This is the same seat of Rai Bareli, which is now held by the daughter-in-law of Mrs. Indira Gandhi, Antonio Maino, aka Sonia Gandhi. So this is the only seat even today which is there in the with the Congress party. So even then, at that point in time, Mrs. Gandhi contested from Rai Bareli, and against her contested Mr. Raj Narain, who was a candidate of Sanyukt Socialist Party. He lost. Mrs. Gandhi won. But he challenged the election of Mrs. Gandhi uh, by way of an election petition under Article 324 in Allahabad High Court. And his grounds majorly were twofold. First, that she spent the money from the state coffers for her election campaign. So when her rallies were organized, her transportation was there. She was lifted through helicopters from place to place for her rallies. It all took place from state coffers. And secondly, her election agent, one guy by the name Yashpal Kapoor, was a secretary in the government of India. Because he was a government servant and he became the election agent of a political candidate, Mrs. Indira Gandhi. So this is misuse of public office. Now, interestingly, here also, it's all about the question of facts and application of question of law to these facts. That Kapoor resigned on 14th of January. His resignation was accepted on 25th of January. He became the election agent on 1st of February. But his resignation was published on 12th of February. So contention of Mr. Raj Narain was that anything which is of public importance till the time it is published, it doesn't come into force. So he took the analogy of any law. So when a law is passed by the parliament, it is signed by the president, but till the time it is notified, till the time it is not notified, it doesn't become a law. So that is why he said that although his resignation was given on 14th of January, but since it was published on 12th of February, he was still a member, a secretary in the government of India for a period of 12 days. So the public perception would have been that a government servant is asking for the votes for a political candidate. We should give the vote to the particular political candidate. So these were the grounds. An election petition was filed in Allahabad High Court, and Justice Broom was the presiding judge. He asked Mrs. Gandhi to reply. So it happens in every petition that the petitioner files a petition and respondent gives the reply. Mrs. Gandhi said that I cannot reply because I am the Prime Minister and any reply would have political repercussions. And since I am in a public office, I am holding a sense of privilege, a public privilege. So I cannot give the reply. So, against the order of Justice Broom, she preferred one SLP in the Supreme Court. SLP was filed, it was tabled before a bench of 3 judges. These judges were Justice Hegde, Justice Grover, and Justice Khanna. The bench said, no, you have to give the reply. But okay, you are in a public office, so you do one thing. You give the reply to us in a sealed cover. So this is one provision which generally court adopts, that if it's something sensitive, the court asks the party to submit the document in a sealed cover. So it is not supplied to the other side and only the judge can see. It is not reported. So the bench asked Mrs. Gandhi to give the reply in a sealed cover. Interestingly, these 3 judges, Justice Grover, Justice Hegde, Justice Khanna, all 3 of them were in the line to become the Chief Justice of India. And unfortunately, 3 of them were superseded by Mrs. Gandhi. Justice Grover, Justice Hegde in 73 and Justice Khanna in 77. So the SLP was in favor of Raj Narain against Mrs. Gandhi. But in the meanwhile, the judge of the Allahabad High Court, Justice Broom, reversed his order. He said, no, the election petition drafted by the councils of Raj Narain is vague. One paragraph 5 is very vague, so I cannot ask the respondents to file the reply. I take it back. So there were some allegations that Mrs. Gandhi ensured that some relative of Broom is harassed, Justice Broom is harassed, so that Broom gives this order. Again, this order was challenged. This order was challenged by Raj Narain, and again Supreme Court ruled against Mrs. Gandhi. They said no, the petition is very valid. The Allahabad High Court should decide this petition. This was the second blow to Mrs. Gandhi from Supreme Court. And by December 1971, the India-Pakistan war broke out, and fortunately, India won that war, and we were able to liberate Bangladesh. So it was victory for India. India was hailed around the globe because America was with Pakistan at that point in time. Still, India was able to secure liberation for Bangladesh. So India was hailed, and since Mrs. Gandhi was the Prime Minister, she was also hailed. So this petition went to backstage. Nobody was interested as to what is the status of this petition. But this petition went on. And Mrs. Gandhi was now aware that Supreme Court is not with me. I try to control the court, and court every time rules against me. And she was also annoyed by the uh, judgments of Supreme Court in various cases, like Golaknath, where they said that no part of the fundamental rights, part 3, can be amended by the parliament. So Mrs. Gandhi was taken aback. She was irritated, literally irritated by the uh, decisions of the Supreme Court. And then there was one bank nationalization case. We have one student with us who is attending this webinar. He has written one very good article on one of the platforms about this bank nationalization case. 50 years completed this year. So bank nationalization case also, only one judge was in favor of Mrs. Gandhi. Yeah. So it was 10:1 judgment, bank nationalization. So Mrs. Gandhi knew that I have to control the judiciary. So on 24th of April 1973, Keshwananda Bharati judgment came. Chief Justice was Justice Sarvamitra Sikri, and the decision was 7:6 in favor that basic structure cannot be amended. And the very next day, on 24th of April, Justice Sikri, the Chief Justice Sikri, was to retire. And next in line was Justice Shelat. Then was Justice Grover, Justice Hegde. So these three were in line to become the Chief Justices. But Mrs. Gandhi saw that Shelat, Justice Grover, and Justice Hegde earlier ruled against her. So she made she ensured that these judges do not become the Chief Justice. So then number 4, who was not in line to become the Chief Justice, Justice A.N. Ray, Justice Ajit Nath Ray, was offered the Chief Justiceship. He was made the Chief Justice, surpassing his 3 seniors. The next day, he took the oath on 26th, and these 3 judges resigned. Now, Justice A.N. Ray was Indira Gandhi's man. So there was one person, first Solicitor General of India, then became the Attorney General of India, Daftari, C.K. Daftari. He said in Parliament that the boy who wrote best essay won the prize. So Justice A.N. Ray was the sole judge who wrote the judgment in favor of government in bank nationalization case. So according to Daftari, he was the best essayist. So he won the prize. He won the Chief Justice. Now again, the Chief Justice was of Mrs. Gandhi, and this petition after Broom in Allahabad High Court, the new judge, Broom retired, and new judge was K.N. Srivastava. Then again, one question of law came. There is something called Blue Book. Blue Book is basically the account book of the persons like Prime Minister, where their travel history is written. So when this election petition was contested in Allahabad High Court, the petitioners demanded that Blue Book should be tabled. It should be exhibited. So Justice Srivastava allowed it, okay, because the travel expenses of Mrs. Gandhi were in question, so Blue Book should be exhibited. K.N. Srivastava, the judge in Allahabad High Court, accepted the argument, passed the order. But again, Mrs. Gandhi approached the Supreme Court in SLP. Now the Chief Justice was hers, Justice A.N. Ray. And he constituted a 5-judge bench. This was a question just of evidence, a simple evidence question. This was not a constitutional question that you should constitute a 5-judge constitutional bench. But Justice Ray constituted. And SLP was allowed. So this was the first decision by the Supreme Court in favor of Mrs. Gandhi. They said, okay, the Blue Book should not be exhibited. But again, there was an order. They said there was a rider that although it cannot be exhibited, but the judge, the presiding judge, can see the Blue Book in camera. So that means that he cannot show it to the petitioners, but he can have a look at the blue book. So this was the decision. Now the petition went on, and even K.N. Srivastava retired, and came Justice Jagmohan Lal Sinha in his place. And on 12th of June 1975, finally the election petition was disposed of. And Justice Jagmohan Lal Sinha held that the election of Mrs. Indira Gandhi as a member of parliament from the seat of Raebareli is void. So her election was set aside. And she was given 21 days to either appeal or resign. This was under Rule 26 of Order 21, Civil Procedure Code. So 21-day period was given to her to appeal. Now, Supreme Court was on vacation, so regular work was not going on, but a vacation bench was sitting. And on vacation bench, interestingly, there was a judge who is well known today for his lucid judgments, Justice V.R. Krishna Iyer. Mrs. Gandhi decided, on advice of her yoga teacher, Dhirendra Brahmachari, and one of her Jyotishis, that 20th June is the correct day to mention the case. So on 20th June, the mentioning took place in the court. Now, general rule is, if you have to file one SLP or appeal or statutory appeal, SLP or writ, anything in the Supreme Court, you have to move it through the registry. You have to file it in the Supreme Court registry, and registry tables it before the judge. But there is another way, which is through mentioning. So they preferred to go by the way of mentioning, directly going in the court of the judge and saying, "Sir, my case is urgent. Please list it and dispose it off immediately." So they decided to mention the case on 20th of June 1975 before the bench of the single judge, Justice V.R. Krishna Iyer. And on the same day, they organized one rally in the boat club. Now, when you see the map of Lutyens from on the one side of India Gate, on the Tughlaq Road, on the Tilak Marg, there is Supreme Court, and on the other side, on the Rajpath, there is Boat Club. So it's on the straight line. 1.5 kilometers from the Supreme Court, there is Boat Club. So Mrs. Gandhi organized this rally to pressurize the court that public is with me, and you have to overrule or at least give a complete stay over this decision of Jagmohan Lal Sinha. Matter was mentioned, and it was listed on 23rd of June. 23rd of June, the court assembled in the morning, and there is one interesting anecdote of the records. Justice Krishna Iyer also mentions it somewhere in his biographical notes. He says that I was to preside the court on that day, the vacation bench. And on the previous night, I received calls from the workers of Congress party saying, "This matter is being listed before your bench. If you do not pass it in favor of Mrs. Gandhi, your wife will be widow next morning." And he writes that I laughed out my heart because my wife had passed away years ago, and these congressmen were threatening me that my wife will go widowed. So anyway, this is one anecdote, but it was listed on 23rd of June 1975. The matter went on for whole of the day till around 5 o'clock in the evening without a lunch break, because courtroom was jam packed. There were chief ministers sitting there. There was Rajiv Gandhi, the son of Mrs. Gandhi, who was there in the courtroom. And there were stalwarts who were arguing. From the side of Raj Narain, it was Shanti Bhushan, who went on to become the law minister. And from the side of Mrs. Gandhi, it was Nani Palkiwala who appeared. And arguments went on for the whole day. It was said that even if judge wanted to go, He had no option because courtroom was jam packed, and the judgment was reserved for next day on 24th of June, 1975 at 3 p.m. The judge pronounced the judgment in his chamber, not in the open court, in his chamber. And to the shock to the ruling party, the court didn't give complete stay. It was a partial stay. So it said that Mrs. Gandhi cannot receive a salary as the minister of as a member of parliament. She cannot sign the register. She cannot vote in the parliament, but she can only remain as the prime minister. So it was argued in the court that since she is the prime minister, so the ruling party has to have some internal elections to choose another prime minister. So her election as the prime minister should be intact. So a partial stay was given. They said, okay, she can just remain the prime minister without having any right to vote, without having any right to salary, without having any right to sign the register. Now, this was a shock to the prime minister, and the opposition got the opportunity to raise their voice. Even otherwise, there were the opposition was there against the government. There were many issues going on in the country. There were strikes in Gujarat, in Bihar by the student leaders, and everything was going on. And on 26th of June, the leader of that time, Lok Nayak Jayaprakash Narayan, he organized one rally in Ramlila Maidan. So Madam Gandhi was being pressurized, even from within Congress, she was being pressurized that she should resign as the prime minister. She was getting letters. Even Jayaprakash Narayan wrote a letter that Indira, you have played in my lap. You are the daughter of Nehru, with whom I worked in the Gandhian movements, and I advise you, you should resign, not as a political opponent, not as a social leader, but as someone who is a well-wisher of yours. But she was the prime minister, and her daughter-in-law, Menaka Gandhi, in one of the interviews, has said that regardless of what she had or what she didn't, but she had a very strong sense of self-preservation. So, on the evening of 25th of June, uh, at her place, many leaders were there. The Chief Minister of West Bengal, Siddharth Shankar Ray, uh, the Home Minister, the party president of Congress, Barua, everyone, these leaders were there, and of course, her son, Sanjay Gandhi, they all were there, and they were planning something. They decided to draft a letter and send it to the Rashtrapati that emergency should be invoked. Um, Although Menka Gandhi says in one of her interviews that Sanjay Gandhi was not the architect of emergency, uh, but they were the leaders like Barua or Siddharth Shankar Ray, who had a very strong left leaning, who were adamant. And they said to Mrs. Gandhi, so as per Menka, there is no record, but as per Menka Gandhi, Indira Gandhi wanted that Babu Jagjivan Ram should be made the prime minister, and she should resign. And when her case is resolved, she should come back as the prime minister. This is the record as per Menka Gandhi in one of her interviews. But Barua and Siddharth Shankar Ray told her that once you are gone, you are gone. Then you cannot become prime minister ever. So, as it was her sense of self preservation, she decided to remain as the prime minister. So, she decided to draft something which was being drafted, and there were discussions. And there were discussions to the extent that the electricity of all the press houses would be cut so that no news is circulated in India. Connection is lost. And secondly, to the shock of us as the law students, it was also being considered that all the high courts should be locked So from next morning, no High Court can work. From 26th of June 1975, no High Court should work. Although this didn't happen with the intervention of some of the leaders, and one of the members of media wing, Mr. Surya Prakash, who headed the Prasar Bharati, has also written in his book that it was Sanjay Gandhi who was adamant that High Court should be locked, but other leaders intervened. And maybe it's just the oral record that Indira Gandhi was assaulted by her son, but it was again decided that High Courts will work. And there was a letter which was written by Mrs Gandhi and given to Rajiv Dhawan, her confidant, who recently passed away in 2018, August 2018. And this letter read, and I must quote this letter: Dear Rashtrapati ji, as already explained to you a little while ago, information has reached us which indicates that there is an imminent danger to the security of India being threatened by internal disturbance. The matter is extremely urgent. No, what was the emergency? There is one report which is given by all the governors to the Rashtrapati, to the president. It's a protocol, and there was no report of any emergency, any situation which may alarm the country, which was given by any of the governors. There was no report of the Home Ministry. There was no report from the Intelligence Bureau. Even the Law Minister had no idea that emergency is invoked. But Mrs. Gandhi said that there is some extremely urgent cause which may cause imminent danger to the security of India. And she also writes that I would have liked to have taken this to the cabinet, but unfortunately, this is not possible tonight. That means even cabinet didn't know, and this is on record. I am therefore condoning or permitting. Condoning is fine. Permitting. I am permitting. Who are you? Permit. But I am therefore condoning or permitting a departure from Government of India Transaction of Business Rules 1961. I shall mention the matter to the cabinet first thing tomorrow morning. So the cabinet came to know at 6 a.m. on 26th of June that emergency has been imposed, and the electricity of the media houses, those which are located on Bahadur Shah Zafar Marg, it was cut. But some newspapers did publish on that day, and they declared that emergency has been invoked. The leaders were arrested from around the corner. In fact, this Raj Narain was arrested the very same night. Jayaprakash Narayan was lifted and he was taken to AIMS. From AIMS, he was taken to PGI, and it was circulated, it was notified in the news that he is under coma. While he said that I am very much in my senses, fit and fine, but they have kept me in the PGI hospital in Chandigarh. So this was the state of affairs at that point in time. And there was one person, the secretary to the Lieutenant Governor of Delhi, Naveen Chawla, who made a call to the prison in charge of Tihar Jail, the superintendent of Tihar Jail, and he told them to keep the leaders in the asylum home, in the asylum cells. He said you should keep the political prisoners in the asylum cell or the cells which are made for lunatics. So when later on Justice Shah Commission was constituted by Morarji Desai government, which looked into the emergency, this Shah report said in very clear terms that Naveen Chawla is not fit to hold any public office, any sort of public office. But as things would have it, Naveen Chawla was made the chief election commissioner by the UPA government led by Manmohan Singh, or UPA led by Sonia Gandhi. So this was the thing, and press was shut. The inspector generals of states were made the censor chiefs. So any newspaper article, if it had to be published, it has to go through the IGs of the state, IGPs, the inspector generals of police of the respective states. This was the condition at that time. All major leaders were arrested. Atalji was arrested. Advani ji were arrested. Even congressmen were arrested. Chandrasekhar, who later went on to become the prime minister, he was also arrested. He was a congressman, but he had said after the partial stay of Justice Krishna Iyer, he had requested Mrs Gandhi to resign. So even he was arrested and put behind the bars. So this was the state, and now her election petition also surfaced. So it was a partial stay which was given on 24th of June. So court opened on 14th of July. As soon as the court was open, there was a mentioning which was made by Raj Narain side that matter should be listed. So matter was now listed on 11th of August, and now it was being mentioned before the court of Justice A.N Ray, who was Mrs Gandhi's Chief Justice. So matter was listed on 11th August, that was Monday. In the meanwhile, there were two major amendments which were passed by the parliament. One was the Election Law Amendment Act 1975 and the Constitutional Amendment, 39th Constitutional Amendment, which was passed. Interestingly, generally it takes days to pass one constitutional amendment. It is tabled in the parliament in one of the houses, generally the Lok Sabha, and a buffer period is given, a cooling period is given, so that members of the parliament can peruse the whole amendment bill. Then a later date is fixed. For the discussion, and then after the discussion, it is passed. This is the general course of business in the House. But this 39th amendment was tabled before Lok Sabha on 7th of August 1975. Madam Gandhi had 352 seats, overwhelming majority. It was passed with a token discussion on the same very day. The next day, it was tabled before Rajya Sabha on 8th. It was passed by the Rajya Sabha on 8th of August. Now, this was an amendment which was to be ratified by at least 50% states as per Article 368. And most of the state governments were ruled by Congress. A special session was called of Vidhan Sabhas on Saturday, the 9th of August, and it was passed by all the Vidhan Sabhas on that day. 50% rule was satisfied. Then, Sunday, the 10th of August, President, the rubber stamp, Fakhruddin Ali Ahmed, he signed the Amendment Act, and the very same night it was notified. So within 3 days, the act came into existence. And the matter, Mrs. Gandhi's matter, was listed on 11th August in the morning. So the advocates of the other side got the gazette which had this amendment in the court itself. And what did this amendment said? It said that no election of a member of parliament who goes on to become the prime minister or the speaker of Lok Sabha can be challenged. And this would be applicable retrospectively. So that means Mrs. Gandhi's election couldn't be challenged, which also means that the SLP cannot sustain. But according to me, since the Allahabad High Court had already given the judgment. So you couldn't have said that now Mrs. Gandhi's election cannot be challenged, because there is already one verdict. After the verdict, you cannot say that it cannot be challenged. It was now at the appellate stage. But I don't think this was argued at that point in time. At least I didn't find it in any book. So the lawyers, since they got the gazette copy in the court itself, and they were not prepared that this kind of thing would be passed and so immediately, so they asked for some time. Next date of hearing was 25th of August. There, the advocates were frisked before entering the courtroom. So there is generally, when you enter the Supreme Court premises, near the gate there is one frisking. But to enter the courtroom, there is no frisking. And for the advocates, generally also frisking is done away with. But to enter the court also, the advocates of Raj Narain were frisked. But advocates of Indira Gandhi were not frisked. And now, Nani Palkiwala was no more representing Mrs. Gandhi. The day she imposed emergency, on 26th of June, Nani Palkiwala resigned, returned her brief. And others also, Mr. Nariman. Mr. Nariman was Additional Solicitor General. He also resigned after Mrs. Gandhi invoked emergency. So the advocates of Raj Narain were frisked in the court while entering the courtroom, and they objected to it. There was a resolution passed by the Supreme Court Bar Association, and Chief Justice was also condemned. Nevertheless, this all happened, and the the matter again resumed. The lawyers demanded that there is one judge on the bench. He should recuse. He should not sit on the bench. He was Justice M.H. Beg. Why should he recuse? Because Justice M.H. Beg was the election agent of Pandit Nehru in 1962 elections, general elections. And when Pandit Nehru passed away, so they had their ancestral home, Anand Bhavan in Allahabad, Prayagraj. So Pandit Nehru's will was to be executed. It was to transfer, the house was to transfer from Pandit Nehru to Mrs. Gandhi. So there is a witness to the will and witness to the transfer. So the witness to the transfer of Anand Bhavan from Pandit Nehru to Mrs. Gandhi was M.H. Beg. Gitanjali, I'll answer the question. So M.H. Beg was the witness to that transfer deed. So they said that M.H. Beg is personally involved with one of the parties, so he should recuse. He didn't, and the matter was argued. There were also advices from the different lawyers that you should not argue the case because fundamental rights are suspended. You cannot argue the case, and you also have to argue 39th Amendment. You cannot argue against the amendment without the presence of Article 14. Parity, arbitrary action, anything, you have to have Article 14. But since Article 14 is suspended, so you should not argue. You should simply say that as per 358 and 359, we can have adjournment, stay in the proceedings till the time fundamental rights are back into existence. But there were some lawyers who were adamant. They said, no, we will argue. So the matter of Mrs. Gandhi's election petition, Mrs. Gandhi's SLP against her election was heard by the Supreme Court till 8th of October. And on 7th of November, the judgment was pronounced. And it was so pronounced that Mrs. Gandhi very well knew what is to be pronounced. So a day before, she went on vacation. And on 7th of November, a bench of 5 judges, Justice A.N. Ray, Justice H.R. Khanna, Justice Matthews, Justice Beg and Justice Chandrachud, Senior, they pronounced the judgment. Three judges held that 39th Amendment is unconstitutional. But they declared, the whole of the bench declared that Mrs. Gandhi's election is valid because there was also one Election Law Amendment Act which was passed. And according to it, there was to be one separate parliamentary committee which was to decide any election matter and any election dispute as to the election of Prime Minister or the Speaker. So they said, according to that, that is pretty fine. So Mrs. Gandhi's election is valid. That judgment is in favor of Mrs. Gandhi. So the judgment is over. But emergency is still there. And who were the two dissenting judges who said no? Even 39th Amendment is valid. They were without any shock. They were Justice A.N. Ray and Justice M.H. Beg. They said no, even 39th Amendment is valid. Now, review was also filed by Raj Narain. Review was also dismissed. Mrs. Gandhi's election was declared valid. But in the meanwhile, since emergency was already there, Mrs. Gandhi found it as an opportunity to control the whole legal system. There was one case which was very less talked about, rarely talked about any. You see in any textbook of constitution also, this case is rarely talked about. This is I. Jagadeeswara versus Union of India. This case was about, they challenged the one of the constitutional amendments, and Mrs. Gandhi wanted to overrule Keshwananda Bharti, and she had her own Chief Justice, Justice A.N. Ray. So even after many advices to the petitioners that you should go to the High Court first, and we know what High Court will rule, but by the time High Court will give the decision, emergency will be lifted, then you can come to the Supreme Court. But Mrs. Gandhi ensured that petitioner files the petition against the state so that the Supreme Court can relook the basic structure doctrine, relook the Keshwananda dictum. So this matter was filed, I. Jagadeeswara versus Union of India. And A.N. Ray constituted a 13-judge bench. So generally we read that 13-judge bench was only constituted once. That was for Keshwananda Bharati. No, even in I. Jagadeeswara, 13-judge bench was constituted. And this bench was to decide whether to refer this matter to an even larger bench, to a bench of 15 judges. Because the question of law in this matter was, can the parliament amend the part 3 of the constitution? So Keshwananda was already there, a 13-judge bench decision. So any decision to overrule Keshwananda would have to be by a larger bench. So this bench was to decide that. It was a 13-judge bench, and interestingly, the judges 7:6 of Keshwananda, 7 who ruled in favor of basic structure and 6 who ruled against. Most of the judges of those 7 majority judges had superannuated by that point of time. So Ayn Rand ensured that other judges who will be in favor of Mrs. Gandhi will come. And he had planned that we will overrule Keshwananda Bharti while by constituting a 15-judge bench. So immediately Nani Palkiwala was called. He usually practiced in Bombay. He was called to Delhi to argue this matter. The matter started on 9th of November, just 2 days after the decision in Indira Gandhi election case. Matter started. Nirende from the side of the state and Mr. Palkiwala from the side of the he was interlocutor. He filed one IA intervention application, and he was interlocutor. He argued. He said that emergency is being invoked. There is no cause to relook at Keshwananda Bharti since we do not have the recourse to any fundamental right. So this is not the correct time to relook at Keshavananda Bharati. And he spoke for the whole day without a single piece of paper. Ultimately, on 12th of November 1975, just after 3 days, the bench was dissolved. Even the Chief Justice Ray had to say that there is no substance in the petition. We cannot refer it to a larger bench. So when Justice Khanna, Justice H.R. Khanna, writes his autobiography, Neither Roses Nor Thorns, so he mentions there that it was not Nani who spoke in the court that day. It was as if the divine was speaking through him, and it saved the constitution. Again, the attempt of Mrs Gandhi to overrule the basic structure doctrine fell. Now, there was another attempt, and this attempt uh, was through the political prisoners. So, there were two major laws. One was the Maintenance of Internal Securities Act, MISA, interestingly, and the second was Defense of India Rules. So, MISA, interestingly, the political prisoners were arrested under MISA. Uh, so, one of the leaders who was arrested was Mr. Lalu Prasad Yadav, and his wife was expecting a baby at that point in time. So when her daughter was born, he named her Misa Bharati. So even we have a leader, a member of parliament. She was Misa Bharati. So she was named after this particular act. So by these acts, the political prisoners and the politicians, the opponents were arrested, and even in the preventive detention. So they were detained, house arrest, in the jail, everything was done. So there were a lot of habeas corpus petitions. For the non-law students, if we have here, so habeas corpus petitions are filed by the detainees basically who are detained, saying that we should know the reason of detention, and or if our detention is illegal. So a lot of habeas corpus petitions were filed. They were filed in the High Court under 226. High Court view were divided. There were 8 high courts which decided that okay, habeas corpus petitions are maintainable. Other high courts decided no, fundamental rights are suspended, so habeas corpus petitions are not maintainable. So Supreme Court dealt with the matter. Matter reached to the Supreme Court. Some writ petitions were directly filed in the Supreme Court. Some SLPs were filed. Supreme Court clubbed them all, and the matter was listed by the title A.D.M Jabalpur versus Shivakant Shukla. A 5-judge bench was constituted, a bench in which all the judges were to become the Chief Justice. There was the sitting Chief Justice, Justice A.N. Ray. Next in line was Justice Hansraj Khanna. After him was Justice M.H. Beg. After him was Justice Y.V. Chandrachud. And after him was Justice P.N. Bhagwati. So 5-judge bench of judges, all of whom were destined or in the line to become the Chief Justice of India. Matter was heard. Again, the Nani was called, and Nani said, "It's a simple matter. Why do you want me to appear? It's a very clear-cut matter. Habeas corpus should be maintainable. So even a less senior advocate can deal it. No need for me to come." He didn't come for this matter. Matter was listed. It was heard. Interestingly, there was one conversation, one dialogue between the then Attorney General A.N. Ray and Justice H.R. Khanna. Justice Khanna said, "Mr. Ray, Mr. Attorney General, tomorrow if a police person decides to shoot a person in custody, can that person not approach the court?" And Attorney General Narain V answered, "Your Lordship, it may shock your conscience, it may shock even mine, but that person has no right to approach the court. There is no fundamental right there." In fact, there was one case in Bombay High Court also. where it was argued from the side of the state that even if state decides not to provide food to the inmates, that inmate cannot approach the court because even right to food is suspended. So a person has no right to have food in jail. So these were the arguments which were put forward. Logic would have been that habeas corpus should have been declared maintainable. But 4 is to 1. It was decided that during emergency, under Article 358, all the fundamental rights are suspended, including right to life under Article 21. This was the decision of 4 judges. 4 of them became the Chief Justice. But there was one dissent. And before writing this dissent, Justice H.R. Khanna, he spoke with his sister. They were Haridwar or Rishikesh for Baisakhi. And he said, and he writes in his autobiography, he said, Saroj, I have drafted this judgment, and I know that this judgment will cost me my Chief Justiceship. So that one dissent was by Justice H.R. Khanna. He said, very important for the human rights jurisprudence, he said, as long as there is constitution, as long as we are democracy and there is a constitution, there always remains a right to approach the court under Article 32. You cannot bar judicial review. There is always a right to approach the court. And tomorrow you have a autocratic government. Tomorrow, if your leader decides, he didn't write this, but this was the inference from the language, but this was what he wrote. He said, even if there is no constitution, then also there is a fundamental right to life, because it is not the constitution which confers the right to life. Right to life is inherent in man. Constitution just recognizes it. Constitution doesn't do any more job than recognizing the right to life. Right to life is inherent in every person. But this was the dissent. Majority judgment held that fundamental right is suspended. Right to life is suspended. Now, in January 1977, Justice A.N. Ray, finally he was to retire, because even if Mrs Gandhi wanted, a judge cannot continue after 65, although there is a provision in. And next in line was Justice H.R. Khanna. But as he also observed it earlier, there was and he writes very beautifully in his autobiography. He says that I knew when I rose from my court, he used to sit in courtroom number 2 in the Supreme Court. He said, today when I rose from my court, I knew this was, and took out my gown, I knew this was the last time I had wore that gown, and I'll never require it again. In the evening, there was an announcement in the radio that Justice M.H. Beg has been appointed as the Chief Justice of India, who was junior to Justice H.R. Khanna, which means he was superseded. The very next day, he tendered his resignation. Interestingly, Justice A.N. Ray, who became the Chief Justice, in A.D.M Jabalpur, where Justice Khanna wrote this, that fundamental right of life, right to life cannot be suspended even if there is no constitution. Justice M.H. Beg wrote that Mrs. Gandhi is treating the political prisoners as a mother. This is written in the judgment. There is a motherly reaction of the state, maternal behavior of the state. This is what he wrote in the judgment. And he wrote that it is just an attempt by a mother to detain her kids who are trying to burn the house. This was the language of the person who became the Chief Justice. He said, so there is nothing wrong in detaining them. It is all well, and Indira Gandhi is like a mother to them. And he became the Chief Justice. Nevertheless, it was in January itself when it was announced that elections will take place. So, in March 1977, election results came. And mind you, even till then, emergency was not lifted. Because, as per some of the authors, Indira Gandhi was of the opinion that if I lose, I'll declare that elections are not valid, and emergency is still there, and I will still be the prime minister. I'll continue as the prime minister. But this didn't happen. Election results came in March 1977. Madam Gandhi lost the seat of Raebareli. Her son, Sanjay Gandhi, also lost. Most of the Congress leaders lost the election. And on 21st of March, finally, the emergency was lifted. So this was the journey, this was the story of emergency. And there were innumerable stories of emergency. Because when we see the leaders of today and leaders who followed the phase of emergency, they were all the products of the protest and emergency. Be it the Prime Minister who immediately followed Mrs. Gandhi, Morarji Bhai Desai, he was also a political prisoner in emergency. Then Chaudhry Charan Singh, who became the next Prime Minister. Again, interestingly, with the support of Mrs. Gandhi, outside support. So after Morarji Bhai Desai, he was Deputy Prime Minister in the Morarji government, Chaudhry Charan Singh. But he was ambitious. He wanted to be the Prime Minister. Janata Party broke. And Mrs. Gandhi extended him support, although she was not in parliament, but Congress party extended him support from outside and made him the Prime Minister. Ultimately, as Congress did it with Chaudhry Charan Singh, as Congress did it with later on in 1991, Congress victory, and also with Gujarat in 96, 97, 97. Congress did it with Chaudhry Charan Singh also. They withdrew the support. Again, Chaudhry Charan Singh government failed, and Mrs. Gandhi again came back to power. Again, other leaders, Atal Bihari Vajpayee. Atalji was minister in Morarji Desai government, external affairs minister. Lal Krishna Advani ji was information and broadcasting minister. Even the ministers of present time, Arun Jaitley was arrested. He was the president of Delhi University Students Union. He went on to become the finance minister and defense minister of country. The current law minister, Ravi Shankar Prasad, he was also arrested. He was a student leader in Bihar. He now became the law minister. Nitish Kumar, he's now the chief minister. He was also arrested. And the leaders of those times, the student leaders of those times, became the leaders or the political stalwarts of times to come. But as the things would have it, as media also accuses, the political memory of the country is weak. So Mrs. Gandhi again came back to power in 1980, and she was the prime minister till her death on 31st of October 1984. And interestingly, there was another judge, and with this small anecdote, all the story of the emergency is over, but we are just dealing with some anecdotes. Last anecdote for the day, there was another judge, Justice P.N. Bhagwati, whom we generally hail as the judge who introduced PIL jurisdiction, many other public interest things, even the environmental law jurisdiction and jurisprudence and all. So just P.N. Bhagwati, he was in the bench of A.D.M Jabalpur, ruling in majority with Indira Gandhi. Then when Mrs. Gandhi went away from power. She lost. P.N. Bhagwati wrote, "This is the end of a draconian autocrat government." Again, Mrs. Gandhi came back to power in 1980. He again wrote, "The sun has shined, the rosy red sun has come back, and India will again shine." So, this was the political stance of that church. There were many other anecdotes in the phase of emergency. Even the current prime minister was also active during those times. But since our time is also limited, and we were only dealing with the legal anecdotes as to what was the case which prompted Mrs. Gandhi to invoke, or which made Mrs. Gandhi so ambitious, so clinging to her seat, prime ministership, that she imposed emergency. So we dealt with that case and other cases which were there, and legal anecdotes which were there. So overall, these were the anecdotes, these within the larger story of emergency. Now we can have discussion. If we have any question, anything, or floor is open. If anybody has some view, we can deal and see. You can unmute yourself and we can discuss the question, then we can call it off the day. Thank you so much for joining at this hour, the midnight, and learning something, contributing something. Thank you.
Thank you. Sorry, but can you recommend some book or some text that can we refer to, not see just the legal aspects, but beyond the legal, the socio-political aspects? How did the citizens take it? The whole,
Of
you said there
emergency.
are many cross stories.
Of emergency.
Yes, emergency related, some book that we can read that
Okay.
is critical,
There
not
is,
just biased.
yes. So there is one book by Shanti Bhushan. Uh, that is good. He has written his commentary. There is one book by J.P. Goyal. He was a junior counsel in that case. He assisted Shanti Bhushan in that case. So that book is by him and edited by his daughter. A recent book released last year, saving saving India from Indira. And there is one book which I was just going through, which I believe has been launched very recently by Mr. Surya Prakash. He was heading Prasar Bharati, and he was a journalist of that point. Then there are prison diaries. So if you read the primary text, it's very interesting. I have also written one work. I have worked on emergency briefly. So I have quoted the diaries, prison diaries of Jayaprakash Narayan and Lal Krishna Advani. So those are the primary texts of the leaders. So you can refer those.
Uh, Thank you, sir. Sir, you said some author who was a council of Shanti Bhushan. Who was that? Saving
JP
India from Indira.
JP Goyal.
Okay, thank you so much, sir. Thank you so much.
Thank you. Is there any jurisprudence of recusal of judges? Um, there are two works, Samarth, on basically jury metrics, not strictly speaking on recusal, uh, but it deals with so many recusals and why a judge did something. There is one book by the title Judges of the Supreme Court of India by Gadboy. He was a US scholar. He came to India and interviewed the judges of the Supreme Court in 1980s, and he wrote the book. And the second book is a very recent book by Abhinav Chandrachud, that is Supreme Whispers. But he has also referred to the notes of Gadboy only. So before passing away, Gadboy passed his notes to Abhinav Chandrachud. So these are two primary books which I know regarding the judges, the internal talks of the judges, and why a particular judge did something. There is one another book on judicial appointments, which also contains anecdotes. This is by Orgo Sen Gupta. Uh, a recent book, 2018 book, Oxford publication. I have yes, appointment of judges to the Supreme Court of India. This is by Orgo Sen Gupta, edited by Orgo Sen Gupta, and has articles from many advocates, senior advocates and jurists. So that is also a good book, contains many anecdotes. So you can refer these books. Yes, Soumya says, did PV Narasimha Rao? PV Narasimha Rao was close to Indira Gandhi. But as they say, it was Siddharth Shankar Ray who was prominent, and Barua. They were advisors to Mrs Gandhi, and Mrs Gandhi was heavily relying on them. And of course, Sanjay Gandhi. Sanjay Gandhi was considered as shadow of Mrs Indira Gandhi, and in some cases, sometimes he was also referred as the true holder of power. Power rested with him. And one thing which he did during emergency, which we didn't deal, was he said that family planning thing. He he advocated the family planning policies within the period of emergency. So there were anecdotes of that time, reportings of that time, that people were taken to the hospitals and their surgeries were done. मतलब, and it was also given at that time. एक नारा चलता था कि हम दो हमारे दोस्त से चला, एंड जो नसबंदी अभियान चला, सो उस तरीके से चला. एंड व्हाट वाज प्रोपगेटेड बाय द रूलिंग पार्टी वाज दैट दिस इज अनुशासन पर्व. तो दे से कि आपातकाल नहीं, अनुशासन पर्व है ये. So this is an opportunity. This is a festival for disciplining oneself. So this was the propaganda at that point in time, which was proposed by Congress, put forward by Congress. So this was the whole scenario, and Sanjay Gandhi played this role, and even his own wife, in the interview says that this was a blunder on his part. He should not have done that. Mixing the emergency with family planning. This went terribly against them. Then there is Kritant, more sessions. Oh, actually, this was the day, 25th, 26th June, the intervening night when emergency was invoked. So we thought that this is an opportunity to have the discussion today. Let's see, you can propose some topics and we can have discussions. Not an issue in that. If I'll be able, in my capacity, to deal with it, I'll definitely try. Or any of you, if any of you is interested to take some sessions, please feel free. We can have discussion and we can schedule the session. Then there is Ankita. Ankita says, sir, is that it never happened again that a judge, it happened. So there are three instances. One was Justice Imam. Justice Imam became the Chief Justice, was to become the Chief Justice before Gajendra Gadkar, Justice Gajendra Gadkar. So this is very interesting anecdote. What happened was that he was very ill, very sick. But and they say that his wife and one attendant used to carry him to the court. He couldn't even sit in the courtroom, and he was being taken by his wife and all, but he was to become the Chief Justice. So his wife was also adamant that he should continue as the judge of the Supreme Court. So Justice Sinha was the sitting Chief Justice. Justice Sinha wrote to Pradhan Mantri Nehru that Imam is not fit to become the Prime Minister, to become the Chief Justice. But Nehru had his apprehensions. He said that since he is a Muslim, and if he is not made the Chief Justice and he is superseded, surpassed by another judge, what will Pakistan say? So Abhinav has also written in his book, Gadboy has also noted that Nehru was apprehensive that what will Pakistan say that you superseded a Muslim judge and didn't allow him to become the Chief Justice. So Nehru was adamant, no, Justice Imam should become the Chief Justice. So Sinha said, okay, do one thing, call him for the tea and ask him to write Supreme Court. If he is able to write, make him the Chief Justice. If he is not able to write, don't make him. Nehru said, okay. He came, he couldn't write. But Nehru was again adamant, I cannot allow the supersession. So he said, okay, I'll constitute one committee, medical board by the doctors of AIMS, and they will decide. A medical board was constituted, and they said the report said that his mental age is of a play school boy, so he cannot become the Chief Justice. Ultimately, he was superseded. This was the first case of supersession, but since there was no political intervention, the prime ministers or the government didn't want the supersession. It was on the medical ground. It is not considered a political ill will or a political play. The second was, of course, Justice A.N. Ray superseding three judges, Justice Hegde, Justice Grover, Justice Shelat. Indira Gandhi wanted it and everything. Then the third was Justice M.H. Beg superseding Justice H.R. Khanna. After that, it has never happened in the Supreme Court. In the High Court, there have been number of instances, but in the Supreme Court, the seniority has been maintained. So what Indira Gandhi said, interestingly, again we missed it out because there are a lot of things in this story, and I said, no, there are many stories touching this. So Indira Gandhi said that there should be a committed judiciary. We have a committed executive. The permanent executive, who are the IAS officers, they are committed to the political executive. So whatever the political executive says, political executive can transfer them, political executive can do anything. So in the same way, there must be committed judiciary. The thinking process of the judiciary, the ideology of the judiciary must be same as the ideology of the government. So Indira Gandhi proposed that, and when she ensured the supersession of A.N. Ray, she defended it. She said that there is no rule. Constitution doesn't say that the senior most judge is to become the Chief Justice. So I ensured that this rule of seniority is done away with for good, because then you have no other option. Whoever is senior is made the Chief Justice. There was another time when political executive made an attempt for supersession. That was by Pandit Nehru for the second Chief Justice of India. So Justice Kania was first Chief Justice. Nehru and Kania didn't go together well, but since Sardar Patel was there, so Sardar Patel used to ensure that everything goes well between the Prime Minister and the Chief Justice. But unfortunately, Sardar Sahab passed away very quickly after independence, and Justice Kania also passed away in office. So next in line was Justice Patanjali Shastri, who was to become the Chief Justice. Nehru didn't want him to become the Chief Justice. He wanted either Justice S.R. Das become the Chief Justice. S.R. Das was active in Congress politics before becoming the judge, or Justice B.K. Mukherjee becomes the Chief Justice. Both of them became afterwards, not at that point. B.K. Mukherjee was a student of Rabindranath Tagore. So he wanted that. Or, very interestingly, he said, if none of these become the Chief Justice, then the Chief Justice of Bombay High Court, MC Chagla, should become the Chief Justice. So MC Chagla, again, interestingly, I mean, we are just dwelling into stories after stories. MC Chagla was a junior of Muhammad Ali Jinnah. He used to work in Jinnah's chamber. And after Jinnah proposed two nation theory, he parted his way with Jinnah and he became close to Nehru. Nehru wanted that, okay, if not Patanjali Shastri, he didn't want Patanjali Shastri, of course. If not Mukherjee, if not Das, then uh, MC Chagla should become the Chief Justice of India directly, not even being a judge of the Supreme Court. He should directly become the Chief Justice of India. But this didn't happen. Justice Mukherjee and Justice Das said that we will resign. If you make any attempt to supersede Justice Patanjali Shastri, we will resign. That was the resolute of those judges. So ultimately, Nehru had to succumb to this pressure. And after 6 weeks, so for 6 weeks, there was no Chief Justice of India. After 6 weeks, ultimately, Justice Patanjali Shastri was appointed as the Chief Justice of India. And again, last anecdote of MC Chagla, then we'll just call it off. So MC Chagla, he was requested to come to the Supreme Court. A close ally to Nehru, he said, no, I don't want to come to the Supreme Court because I want to serve the people of Bombay. I want to serve my people, my High Court. I have emotional attachments with it. Okay. After a few days, he was appointed as the ambassador of India to United States by same Pandit Nehru, and he went. He took this appointment and left his emotionally close Bombay High Court and his people of Bombay. So this was another anecdote of those times. So there are many other anecdotes which happened. There's another question, I think, by Samarth. Why did Indira Gandhi lift the emergency? Because she was under tremendous pressure at that point, and she was being criticized from everywhere. And she knew that people were not with him. Initially, newspapers for international press was also against him, against Indira. And when Justice Khanna gave his judgment, his dissent in A.D.M Jabalpur, New York Times wrote that when emergency is lifted, the name of this person will be written in golden words, and someone will erect the statue of this person in India because he is the harbinger of freedom. Although statue didn't come, but there is one portrait in courtroom number 2, a full life-size portrait of Justice H.R. Khanna in courtroom number 2 on the wall which adjoins courtroom number 1, which is the Chief Justice court. And this, although this is just philosophy, which I usually say, but of course, this portrays and this inspires the judges of courtroom number 2. Even though you may fail to reach courtroom number 1, but if you are honest to your work, then you will be respected. You will be known. So now we have the 46th Chief Justice of India. There have been 46 Chief Justices. And we being law students, I don't think we know the names of more than 4 or 5 Chief Justices. But we know the name of Justice H.R. Khanna, whose portrait also lies in the Supreme Court, who never became the Chief Justice because he stood for his principles. And he didn't stood for his principles when everything was with those things. So there are some judges in recent times who give jurisprudential judgments, who are very famous, considered as the heroes or the cool boys of Supreme Court, but they give the judgment when the societal flow is with them, when they have nothing to lose. But Justice Khanna gave that judgment when everything was against him, when he was aware that he will lose his seat. ask this to him. Then also he came. So that is something very inspiring. Okay. So heard this story from you, Architi. Yes. From sitting in that court only. Yes, Architi was there with me in courtroom number 2. Niti Manthan next agenda, Justice H.R. Khanna. Okay. We'll discuss. Someday we'll discuss the autobiography of Justice H.R. Khanna. Then Samarth has named one person. I'll not take the name. But okay. Fine. If everything is done, it's already 1 hour past midnight, so we can call it off. Thank you